Be seated. We'll take State Farm Mutual versus Mashburn.
May it please the Court, my name is Charles Bell. I represent the appellant, State Farm, in this matter. I'd like to reserve 5 minutes of my time for rebuttal. This should have been a simple case involving a straightforward issue of contract interpretation, and stripped of all the irrelevant issues that arose for the first time at the summary judgment hearing, that's exactly what the case is. The fundamental issue presented by this case is whether Ms. Mashburn is entitled to medical payments coverage under endorsement 6910 to State Farm's policy that was issued by State Farm to her at the time live-in boyfriend, Luis Palacios. The simple answer is that she is not entitled to medical payments coverage under the plain language of that endorsement.
So the affidavit means nothing?
If you're talking about Mr. Burke's affidavit, I think it means what it says, but it doesn't say what they say it says, if I may, Your Honor. What it says is that this was one of the post-accident affidavits of insurance coverage. Mr. Burke said the name of all insureds are Luis Palacio and Joyce Mashburn. As his later affidavit explained, that is a true statement, but it doesn't mean that she is a named insured under the policy. It just means she is an insured under the policy. She is entitled, for example, to liability coverage, medical PIP coverage, which State Farm did pay in this case, and all that, just not medical payments coverage. And that affidavit, importantly, was issued after the accident, so they've tried to use this as an estoppel argument, but obviously Ms. Mashburn and Mr. Palacios could not have acted to their detriment on that affidavit, since the affidavit was not even issued until after the accident. So the affidavit really is, at most, a mistake of words, but we think actually it's an accurate affidavit, but just doesn't mean what they want it to mean in this particular case.
Counsel, why isn't the failure of the agent here, Mr. Patrick, to include appellee in the coverage under the policy a basis for the claim?
Well, the simple answer to that, Your Honor, is that was not pled in the complaint or raised in the summary judgment motion.
But it seems to me paragraph 2 of the motion for summary judgment really raises that, because it says Luis Palacios represented to State Farm's agent Larry Patrick that the vehicle would be driven by Joyce Mashburn. He was not related. He resided with her. He wanted Ms. Mashburn covered to the same extent and with the same protection afforded him under the policy. Why doesn't that raise that issue?
Well, a couple of reasons. One, I don't think that actually specifically says that. Maybe 3 reasons. Second, that really was not part of the complaint. There was no allegation in the complaint for negligent procurement, which is essentially what that is.
What I read to you with reading from their motion for summary judgment.
Exactly, Your Honor. But here's the important thing about that. The policy, when it was issued back in 1997, initially did, in fact, provide the coverage that Mr. Palacios apparently, according to that affidavit, requested. Okay. What happened is in 2002, State Farm added endorsement 6910 to the policy, which changed the medical payments coverage and who was entitled to that coverage. Okay. So the question then becomes, is there a duty on the part of Mr. Patrick to continually go back to the insured and to remember a conversation from 5 years ago and say we need to make sure that this is added, keeping in mind that Mr. Patrick's testimony was this could not have been done, as a matter of fact, because Ms. Mashburn had no insurable interest in the vehicle since she was not the owner at the time. So his deposition testimony says I couldn't have done that. But be that as it may, this was not an issue that was preserved in the summary judgment context, because summary judgment is limited to the pleadings. The pleadings didn't mention an issue of I asked for coverage, your State Farm, your agent did not provide coverage, and therefore we're entitled to summary judgment. So the simple answer is that's not an issue for which they can obtain summary judgment on the record before us.
If Mr. Palacios had put Ms. Mashburn's name on the title, if they owned the car together, she would have been a named insured and entitled to med payments?
He could have. If she had been on the title, then she could have been named as a named insured. Now, whether she would have been is a different issue. But Mr. Patrick's testimony was
he could have achieved his goal
if the car had been titled in his name and he had asked that Ms. Mashburn be added as a named insured, could have happened, no question. No question about that. But it didn't happen in this particular case. And so, you know, stuck on the record that we've got here before us.
What about didn't the judge find that because you amended the statute, you owed a greater duty of notification to them?
Amended the endorsement?
Yes, I mean amended I said statute, amended the policy?
The judge apparently held that, Your Honor, but we don't find any basis in law for that particular holding. I mean, insurance companies issue endorsements amending coverage all the time, and the law in Florida is if you provide that notice with the renewal premium, the premium is paid, then that creates a new contract between the parties, and that endorsement takes effect. That's exactly what happened in this particular case. Mr. Palacios has stipulated that he did, in fact, receive every renewal premium and every declarations page with endorsements attached every 6 months from State Farm from the inception of the policy. That's found at page 838 of the record, the court's order accepting that stipulation. And so we have an agreement by Mr. Palacios that, in fact, he received the notice that is required under Florida law. There's no requirement that the agent make a phone call or that there's a special card sent out or letter. There may be in other areas, coverage, for example, there are heightened notice requirements by statute. There are no such requirements by statute here.
What about section 627.728? How about addressing that? Why doesn't that require some notice there? Well, you got a renewal and you change a material aspect of the policy, which we know under U.S. fire insurance that means that you're supposed to give the notice of why you didn't do it.
And I respectfully disagree for, I guess, 3 reasons, Your Honor. The first is the procedural reason, and that is this issue was never raised before the hearing. So procedurally, this is not a basis for a summary judgment.
On that.
Turning to the substance of it, what Ms. Mashburn has done is confused Section 627.728, which is the statute governing automobile insurance policies, with 627.4133, which is the statute governing property and fire insurance policies. The case you're referring to interpreted that latter statute that addressed property and casualty policies. In that case, the court said that a decision to make a material change, in that case eliminating, I think, personal injury coverage from the policy, was a material enough change that it qualified as a non-renewal and notice was required. Here's the distinction in those 2 cases. Section 627.4133 does not define the word renew. So the 50 CA in that case was entitled to interpret renew to mean a material change. Here, Section 627.728 contains a specific legislative enacted statutory definition of renew, and that definition says an insurance company renews a policy whenever it issues a new policy superseding an old policy. In other words, every 6 months or 12 months, however your policy works, you get a new policy that replaces the old one. That's exactly what State Farm did in this case. It renewed the policy every 6 months.
The legislature intended to allow you to change the material parts of the policy and without specifically notifying the insured and then send out another policy, and that complies with the statute?
Well, that's what the plain language of that definition says, Your Honor.
Let me ask you a sort of a bizarre hypothetical. What if the policy had changed every term in there but one, and you sent it out? That would comply with that literal meaning?
Well, I don't know that it would, Your Honor, in that particular case,
Where do
because
we
at that
draw
point
the
we're
line?
talking about an entirely new policy that could not be compared.
Well, when does it become a new policy? Somewhere you have to draw the line.
And Your Honor,
Your company left out material coverage and this new one without saying, hey, we're not renewing this, and here's why, and the explanation where the insured would pick up on it.
And I disagree with your presumption there.
I expected you.
Well, I figured you would. For this simple reason. In this particular case, State Farm did not eliminate any coverage, did not lower the policy limits of any coverage, did not make any change to all that. It just changed the definition of who is eligible for this coverage. Luis Palacios, the named insured whose contract with State Farm is at issue in this case, had the exact same coverage before and after in this particular case. So while the court may be correct that there may be a point at which material changes become a different policy altogether that doesn't supersede, that's not the case here. We're not in that particular case here.
But he had that coverage for this lady who I gather was his mistress or some type of arrangement there.
Yes.
That, and your agent knew that she was covered by that first policy, and it was changed by the second one, and no notification was given with any specifics, was it?
And I disagree with that, with the characterization of no notice there also, because again, we've got several,
Well, I'm talking about that notice that's required by the statute when it's non-renewal.
well, I don't know that there's a specific form notice that is required by that particular statute. That's certainly not something that was in the briefs, and I don't believe it is. But notice, again, in Florida is given when you provide notice, hey, we're adding this endorsement to the policy, write your check, and you're covered by it. That's exactly what happened. July 30, 2002, State Farm sent a renewal notice to Mr. Palacios. That's located at page 629 of the record. Page 589 and 590 of the record, Mr. Palacios, at his deposition, acknowledged that he received that specific premium. Okay? And there's no dispute that he continued to renew the policy every time. So we believe even if that statute applies, which we don't think it does, then there is conclusive evidence that State Farm complied with it. I'm in my rebuttal time, and I'd like to reserve the rest if that's okay.
Good afternoon. My name is Woody Wesley, and I represent Joyce Mashburn in these proceedings. And I realized when we were, my time's not running. Am I on free time? Okay, thank you. I see I was getting some free time here. I totally disagree, and as I read the briefs over the last couple of days, I realized even in the briefs, Mr. Bell and I adamantly disagree about what this case is about. And I wrote down his initial comment to you, and he said the fundamental issue is whether or not Ms. Mashburn's claim is barred by endorsement 6910 to the policy issued by State Farm in 2002. I submit to you that's nowhere close to the fundamental issue in this case. The fundamental issue in this case is, did State Farm deliver on its promise? That's what this case is all about. Because factually, we know it's undisputed that in September of 1997, 6 years before this May 03 accident, Mrs. Mashburn and her fiancé, Mr. Palacios, personally went to State Farm. Mr. Palacio had been insured with State Farm for about 10 years at that time, was happy with State Farm. He had gotten engaged to Ms. Mashburn. He had bought her a brand new 1995 Ford Crown Victoria. He had agreed to insure it for her. He took her to State Farm and met with the State Farm people. Mr. Palacios' instructions to State Farm are contained in both his affidavit and in Ms. Mashburn's, and they're quite clear, and they're not disputed in this case. And those instructions are simple. He said, Joyce is my fiancée. We're going to get married. I just purchased Joyce a brand new 1995 Ford, and I want Joyce insured just the same as I'm insured on my vehicle. That could not be clearer. State Farm then solicited information from Ms. Mashburn. They got a written application. They got her driving record. They asked her how often she was going to use the car, and she said she was going to use it 80% or more of the time. She was going to be listed as the primary driver on that vehicle, although she'd be listed as an alternate driver on other vehicles. When they left with a quote, a price. They wrote a check for that price, and both Ms. Mashburn and Mr. Palacio left State Farm, left Larry Patrick's office with the promise that she had both what she wanted and what State Farm promised to provide to her. Now,
Counselor, at this point in time, she got that, didn't she?
no, sir.
She didn't?
She didn't get that.
I thought originally the policy would have.
Well, let me tell you what she got, and that's what's significant. She thought she was insured, and we're going to come back to what these terms mean in a minute. But what she got in the mail, and I apologize, I don't have the 1997 response form, but I have the 1999, which supposedly is identical. She got this in the mail. And what it showed her was, one, her vehicle, the 1995 Ford Crown Victoria is listed with the appropriate VIN number. She had the identical coverages, the 7 coverages that Mr. Palacio had on his car. Her name appears. Karen Palacio is Mr. Palacio's ex-wife. I don't know to this day why she's on the policy. They weren't living together. Mr. Palacio is listed. Joyce Mashburn is listed. And the premium is quoted. Now,
Will you please hand that to me?
yes, sir.
Thank you.
Now, the other exhibit, that's 1999. It actually first appeared in 1997. In the policy that was actually issued right before the accident in May of 03, the policy that was in effect from March of 03 to September of 03, been a couple of changes. She's changed cars. So now her 2002 Crown Victoria is listed, which replaced the 1995 Crown Victoria. The coverages are identical. Obviously, like everything, priced on a little bit. The ex-wife is gone. Lou's on the policy. Miss Mashburn's on the policy.
As a licensed driver, but not as a named insured, right?
Well,
But
as
Counselor,
Judge Remington said, he wasn't sure what she was listed there for. But here's what
Counselor,
happened.
in the 1999 policy, she wasn't listed as a named insured either. So is that your point?
Well, that
One of your points.
Mr. Veal says that, that's the fault in our case. I'm saying that's the sin that State Farm committed that should afford us coverage and should allow you to affirm Judge Remington's order. Because every 6 months, one of these sheets came out, and on every one of those, her car was listed, she was listed in the coverage. State Farm concedes that she's entitled to 6 of those coverages on the right-hand side of that form. She's entitled to all the coverages, I think, except the MedPay coverage. But how in this world could you or she or anyone looking at that document decide where she's covered and where she's not? So did she have the...
You said that the sin was that,
Okay.
put on there, but let me ask you this. Your opposing counsel says that you had the opportunity to sue that agent for negligent processing of the application, and you haven't done that in the complaint. Would you address that for me?
Well, we saw no need to sue the agent until such time as we had lost against the State Farm. It's our position that...
But you could have sued in the alternative.
We could have sued in the alternative, but he was their agent, so State Farm, he stands in State Farm's shoes, they stand in his. His representation as to coverage is binding on them. Therefore, we saw no need to sue him personally, and didn't sue him personally. But what happened? There's a... I'm sorry. Did you? Okay. Now, here, I told you that's the sin. What's the problem with this analysis? And that is, Joyce should have been fully insured on that policy. She should have been listed as whatever it takes to be insured. When she walked into State Farm's office, I'm sure she said, I'm here to buy insurance. I want to be insured on my car. I doubt very seriously that she asked to be a named insured. I'm equally sure she didn't say, I don't want to be a named insured. She probably didn't know what that term meant. She could have been a co-named insured, an omnibus insured, an other insured. It didn't mean a hill of beans to Joyce Mashburn what they called her. What it mattered is what she was, and that is, I want to be insured when I drive my car, and I want to be protected if something happens to me. And that never happened. That never happened here.
All right, let me ask you this, and if I'm breaking your train of thought there, I'm sorry. Oh, okay, well, I do too. So, I question opposed to counsel about 627.728, which was the notification after non-renewal. He says that his interpretation of that definition is that if you get a policy, it doesn't matter if there's a material coverage that's eliminated by the endorsement, you don't get the notice that's required in that section.
We both know that makes sense. And I'll come back, I promise you.
All right.
I'll come back to that in just a second.
All right.
You know, she didn't get, when we did the discovery and we asked Larry Patrick, what he said was, because she was a permissive user of the car, not an insured, she had those coverages. A permissive user of the car is the guy at the valet restaurant. When you go to a nice restaurant and the valet guy parks your car, he's a permissive user. Do you really think Miss Mashburn and Mr. Palacio went down to State Farm to buy insurance so that she could have the same protection that the car lot attendant at a nice restaurant has when he drives your car? That's just not reasonable. That's not what she wanted. That's not what she bargained for, and that certainly isn't what they promised.
But what you showed us on those cover sheets, it says that these people will be regularly using the car, but it does not expand the coverage set forth in this policy. In other words, it tells you right there, right above her name, read the policy if you want to find out what she's covered for and what she's not covered for. And you're saying that your client has absolutely no obligation to, do any reasonable due diligence on her part at all.
Respectfully, Judge Collins, that's not what I'm saying. What I'm saying is when she went into the State Farm office and she told them what she wanted, and they told her that's what you've got, and they sent her that appeared to her to confirm all her suspicions. Had her name not been on there, had her car not been listed, had the coverages been different,
and no matter
then
what
she
they
would have
mail her in
questioned.
the ensuing 6 years. And no matter what they mail her in the ensuing 6 years is not going to change what she left that office believing in 1997.
Absolutely, because under Florida law, a person has the right to assume, unless they're told to the contrary, and this goes back to Judge Browning's question, they have the right to assume that the renewal policy gives them the same protection and affords them the same coverage as the superseding policy. Now, one other point, and then I'm going to come to if I've got time, I'm going to come back to Judge Browning's question. Judge Remington found the policy, all the policies, the language, the affidavit ambiguous. Mr. Bell makes a big point out of the affidavit given by Mike Burke, the head State Farm guy, saying she was a named insured. I agree with him in the point he makes in the brief. That affidavit standing alone cannot and should not be used by either Judge Remington or this court to find coverage. But Judge Remington used it quite differently, and he said it just shows the ambiguity that's in the face of the policy where the head State Farm guy isn't sure whether she's insured or not, and files a sworn document, a statutorily required document, in the court file indicating that she's an insured. I'm going to skip ahead to the notice because I'm about to run out of time, and I just want to read you the language from the case interpreting 727-433 because I think that language is very, very important and goes to the question that Judge Browning asked. And there, a guy had a general liability policy that also provided coverage for personal injury. About 3 years into the policy, they delete his personal injury coverage. One of his employees sues him for libel and slander. Hartford refuses to defend him. He defends himself. I don't know how he did in that case, but he sues Hartford for extension of coverage and payment of defense costs. And they said under that statute, Hartford could not change the deal in midstream. They had him covered for 3 years. They never told him he wasn't covered, so they extended coverage. But their language is very significant. The purpose, and I'm reading from the Fifth District opinion, The purpose of the statute's notice requirement is to enable an insured to obtain coverage elsewhere before the insured is subjected to the risk without protection. The 1987 Hartford policy, which deleted this coverage, was a non-renewal of the 1986 Hartford policy within the meaning of 727.4133. Thus, Hartford was required to give Southern Security written notice of the non-renewal. It's that chance to protect yourself. Ms. Mashburn didn't know it, but she'd not been protected for 6 years. She didn't just become unprotected in 2002. She was never protected to the extent that she bargained for and was assured she had.
Counselor, let me stop you right there now. Assuming
All right?
that your position on the notice or the non-renewal is correct, opposing counsel has also said that you didn't argue this with specificity in your motion for summary judgment, and on that basis alone, we should reverse it and send it back for lack of notice to it, because you only mentioned notice in your affidavit rather than the motion as the rules require.
Judges, you know affidavits can be filed up to the eve of the hearing on the summary judgment. In this case, the affidavits were filed, stapled to, and as exhibits A and B. When they got the motion for summary judgment, they got a packet. They had the motion and they had the affidavits. They were all filed at the same time, so they certainly were on note. I mean, that has been our position throughout, is that the era of State Farm occurred back in 1997 and continued through the day of the accident. I have 3 seconds, so I'll probably better sit down, but thank you so much for your attention.
May it please the Court. With due respect, I think my opposing counsel is arguing a different case than the case he filed. And I think that's the simplest way to put this. He said repeatedly in his argument that Mrs. Mashburn and Mr. Palacios wanted this coverage and that she, quote, should have been covered. But the issue is, the truth is, she wasn't covered. His argument is not that she was covered. His argument is that she should have been covered, and there was some sort of negligence or estoppel type theory coming forward.
But she was covered for a considerable period of time for this very situation that's subject to this case.
That's correct. That is correct.
So it seems to me like the crux of this case is whether or not that coverage, because of lack of notice, leapfrog into the next policy.
It could be, and I will read the complaint.
The crux of the case.
Well, the crux of the case, but I'm going by what the complaint says, and the complaint said, on page 1 of the record, Joyce Mashburn was a named insured under the policy. That's their allegation they're trying to prove. She was a named insured, and that in the second page it says they submitted bills to State Farm and State Farm's refused to pay them. So the complaint alleges that in fact she is a named insured under the policy, which she is not. She's now turning this into an estoppel, hey, I thought I was covered type case. And the answer, I think, to your question, Your Honor, is that insurance companies can, in fact, do change the definitions and change the terms of their policies as policies progress year after year. And it is settled law in Florida, and I think other states, that when an insurance company does that, issues a renewal notice, sends a new declarations page, a new endorsement, and the insured continues to accept the coverage, they have agreed to be bound by that. You cannot create coverage by estoppel by, I'm sorry.
Do you have a case that holds that?
Excuse me?
Do you have a case that holds what you just stated about when you change it with a deck thing, an existing policy, then they're bound by it without that notice that's required by the statute being given?
We cited cases in our initial brief, Your Honor, that says that an insured is bound to has constructive knowledge in a sense of what is putting inside the notice with the mail. Now, we cited, I think, in our brief a Mississippi case for a general proposition that I took to be undisputed. That's the way it works in Florida as well, that when, in fact, an insurance company sends a premium and you agree to it. But the real question then is...
Well, counsel, it seems to me that Ms. Mashburn was never a named insured.
That is correct.
She was covered in 1997 by virtue of a provision of the policy which was then changed. So
Exactly.
she was never a named insured, and
Correct.
you say that her lawsuit never said the fact that she was named insured was a breach of contract or some form of claim because it had been represented to her that she was going to be a named insured.
Exactly. The lawsuit does not allege negligent procurement either against the agent or some estoppel theory against State Farm. Again, his argument is not that she was covered, at least the argument we're hearing today is not that she was covered, it's that she should have been covered. In the complaint, the argument was that she was covered. And in fact, even the summary judgment motion itself, page 143 of the record, talking about the issues that are not in dispute, and their claim, they said the declarations page of the policy, the affidavit we discussed, and the deposition testimony of State Farm's agent, Larry Patrick, indicate that State Farm's position was that Joyce Mashburn was insured and had the same coverage as Luis Palacios. Again, that's not a claim saying, I thought I was covered, you misled me into thinking I was covered in this particular case. And again, Florida does not adopt the reasonable expectations rules that other states have done. If an insurance policy excludes coverage, that coverage is excluded in Florida. As this Court has pointed out, I think in the Tradewinds construction case we cite on page 26 of our brief, estoppel based upon the conduct of the insurer does not operate to bring within the coverage of a policy risks not covered by its terms or risks expressly excluded therefrom, and may not be used to affirmatively create or extend insurance coverage beyond that set forth in the policy. And I think that's exactly the issue we have in this particular case. My time is up. I thank you.